At this point, we've covered several of the exceptions to the warrant requirement. We've already talked about the plain view exception. We've talked about the search incident to a lawful arrest. We've talked about consent and stop and frisk. And at this point, let's move on to the protective sweep. In the case of Bowie, the facts of this case: the police arrested defendant on a warrant as he alighted from his basement. Believing others may be in the basement, the officers conducted a limited search where incriminating evidence, the red running suit worn during the robbery, was found in plain view. In coming to its conclusion, the court held that the rationale was the same as for Terry and Long. Officer safety and the danger, the court held, may be even more, may be even greater in this context, because in this situation you're inside a person's home where that person knows the ins and outs of their home, whereas the police officers do not. So we still have the same sort of danger issues that you would have in Terry that justify the stop and frisk, or at least the frisk portion. But in this, the court said it could be even more dangerous to the officer. The court distinguished this from Chamel, which held that the officer may look only to the immediate area of the suspect for weapons and evidence, because in this situation, you are inside of a home where the officer might reasonably believe harbors another individual, which might pose a danger to the officer. As in Chamel, though, they're looking only for evidence and for weapons that the person may access it to use against the officer. The court held that the Fourth Amendment permits a properly limited protective sweep in conjunction with an in-home arrest when the searching officer possesses a reasonable belief based on specific articulable facts that the area to be swept harbors an individual posing a danger to those on the arrest scene. Keeping in mind here that this is not an automatic sweep. This is not an automatic search of the residence. This protective sweep only exists if the officer has reasonable belief based on some specific and articulable facts that the area to be swept harbors an individual that may pose a danger to those on the arrest scene. Now, those may be based on the fact that, for instance, the officer is chasing someone where he knows that there were more than one suspects, and now they've come into the house, they see that there's a suspect there, but the officer may believe that there's another suspect, or the other suspect to the crime may be inside of the home, but he must be able to articulate some basis upon which he believes that the home may harbor another suspect who may pose a danger to him. The protective sweep is limited. It's a quick and limited search of premises incident to an arrest and conducted to protect the safety of the police officer or others. It's a cursory sweep following the in-home arrest to look for people. So that's going to determine the scope. It's going to be limited to where people might be hiding. So if the officer, as in this case, goes into the basement, he's generally looking for people. He might be able to pull something back where he believes that a person may be. He would look in closet doors. He looked maybe under the bed, but he's not looking in drawers. He's not looking in a refrigerator or anywhere else where the officer knows that a person would not be. So not only must the officer have some specific articulable facts that the premises may harbor an individual who may pose a danger to him. Additionally, as with all of the bases, it's going to be limited by the reasons or purpose that justified it to begin with. And in this case, because we're looking for people, that's going to be the scope of it. So it's not something that is automatic, but it may be conducted only when it is justified by a reasonable, articulable suspicion that a person poses a danger to the police officer. So that's pretty much it for a protective sweep. But keep in mind, just like many of the other exceptions that we have, the protective sweep can put the officer where he has a right to be, wherein while he's conducting the protective sweep, it is possible that if he sees some other evidence within the scope of the protective sweep and it becomes immediately apparent that what he sees is evidence of a crime or contraband, he may seize that evidence as well. So that may form the basis of the officer is where he has a right to be. The next exception that we're going to talk about is the automobile exception. This exception is not based on danger to the officer, but it is based upon probable cause that the vehicle contains evidence of a crime or contraband. It is to be distinguished from a situation where the officer may have probable cause to arrest the individual, as with a search incident to a lawful arrest that occurs in the vehicle and he's searching the passenger compartment for evidence of a crime or contraband or for weapons. In this case, the officer has probable cause to search the actual vehicle, and it allows the officer to search the passenger compartment, trunk, engine, under inside closed containers, or wherever probable cause to believe the vehicle has evidence of a crime. It doesn't matter if the owner or driver has done something wrong or not. Here you're focused on the car and whether there's probable cause to believe that the car has evidence of a crime in it. Let's take a look at the Houghton case. In that case, the officer pulled over a car with 3 passengers and questioned the driver, who admitted to using a syringe found to take drugs. The officer then searched the passenger compartment of the car, including the purse of one of the passengers that the officer clearly knew did not belong to the driver, where the officer found drug paraphernalia and a syringe with 60 cc's of methamphetamines. The issue in the case was whether the police officer can search a passenger's personal belongings inside an automobile that they have probable cause to believe contains contraband. And the court ultimately held that if police have probable cause to search a car, he may inspect the passenger's belongings found in the car that are capable of concealing the object of the search regardless of ownership. In coming to that conclusion, the court took a look at a number of other cases in coming to that conclusion, including Carroll, a 1925 case where the court held that contraband may be searched for without a warrant with probable cause. And they also took a look at the Ross case, where in that case the court stated that during virtually the entire history of our country, whether contraband was transported in a horse-drawn carriage, a 1921 roadster, or a modern automobile, it has been assumed that a lawful search of a vehicle would include a search of any container that might conceal the object of the search. The rationale for allowing the search of the automobile and any container therein, regardless of ownership, in which the officer believes the object of the search may be, the court said that if probable cause justifies the search of a lawfully stopped vehicle, it justifies the search of every part of the vehicle and its contents that may conceal the object of the search. The automobile exception will always include all containers in the automobile that where PC exists to believe the object of the search may be, regardless of ownership. If ownership were the issue, then the passenger could easily just hide evidence and claim that it's their package or that their thing. It would ultimately defeat the purpose of allowing a search based on probable cause if ownership were the issue. Keeping in mind what we said before, here is not about the person or whether the person has done something wrong. We're looking for probable cause that that the vehicle itself contains evidence of crime or contraband. So it is irrelevant at that point as to who it belongs to or specifically who owns the object that that thing may be inside of. Remember, the justification for the search is probable cause that there's evidence of a crime or contraband, and wherever that probable cause exists, that's where you may look, even if it belongs to someone else, if it is capable of concealing the object to the search. And ultimately, the court says to not allow it would conflict with its justification in the first place. Taking a look at the Dyson case. In that case, the defendant was arrested following a tip the previous day from a confidential informant who indicated that the defendant would be returning from New York with drugs. The defendant claimed that there was no probable cause that the officers had time to get a warrant. In the lower courts, the Maryland Court of Special Appeals found that although there was abundant PC, there were no exigent circumstances and that the officers could have gotten a warrant. In this case, the court held that the automobile exception only requires that the car is readily mobile and probable cause exists to believe it contains contraband. The Fourth Amendment permits police to search the vehicle without more. There's no separate exigency requirement. So there was a time when the courts looked at there being or requiring that there be some exigent circumstances coupled with the probable cause. But that standard has changed, and now it's more focused on the ready mobility of the vehicle. And so you have to have probable cause that the vehicle contains evidence of crime or contraband, and you couple that with the ready mobility of the vehicle. So, in other words, if the officer were to go and obtain a warrant, is it possible that the vehicle could basically drive off? And that is sufficient in order to justify the automobile exception rather than specifically there being some outstanding exigency other than mobility. In Carney, the defendant was arrested following a drug for sex transaction in his motor home. The motor home was subsequently searched pursuant to the automobile exception to the warrant requirement. The issue in that case was the court is left to decide if the automobile exception to the warrant requirement applied to motor homes, where there would only need to be a finding of mobility and probable cause rather than the added protections of the Fourth Amendment affords homes. In other words, was the motor home a car or was it a home? If it was considered as an automobile, then the search would be justified if they had by probable cause and the ready mobility of it. If it was considered as a home, then we would need more to search the home. We would need a warrant or some exception to the warrant requirement, and of course, because of the added protection surrounding a home. The court here says applying the rationale for the automobile exception, looking at ready mobility and the reduced expectation of privacy stemming from its use as a licensed motor vehicle subject to a range of police regulation inapplicable to fixed dwellings, the court held that the automobile exception was applicable to the motor home. The defendant stated that it should be considered a home because of its possible use of a home, as a home rather. But ultimately, the court set out these factors to consider if it was a vehicle subject to the automobile exception or if it was, in fact, a home. And amongst those factors included its mobility. Could it actually move? Additionally, its location, if it were on blocks or if it was on tires or if it was on a concrete slab. That's going to determine whether the people could drive off in it if they were to go and try to get a warrant. Was it connected to utilities? How conveniently could it access the road? Was it licensed to move? Did it have all the proper licensing and other equipment that would be needed for it to drive? Based on those factors, the court would be able to determine whether or not it is actually an automobile and capable and susceptible to the automobile exception, or if it was in fact a home where you would not have the benefit of the automobile exception. And so basically in this case the court held that the exception does apply to the motor home, particularly in a situation where it has the ready mobility and capable of being moved. So just a quick review here. With the automobile exception, we're looking for probable cause to search the automobile. We're looking at probable cause that the vehicle contains evidence of a crime or contraband. One of the major factors here for the automobile exception, in addition to probable cause to search it for the crime or contraband, is its ready mobility, considering all the relevant factors in determining whether it is likely that they would be able to drive off if they could drive off. Does it have tires? Is it connected? How is it confined to that location? Or if it's something that is permanently placed. There's no separate exigency requirement. And with the automobile exception, you can search anywhere within a car that the probable cause exists. It might be the passenger compartment, or it might also include the trunk. It could be the gas tank, under the hood, containers inside the car, whether they are open or closed, regardless of ownership. They may have probable cause that the seats, underneath the seats, the lining of them contains contraband, and they would have the authority to pull those out. So the scope of an automobile exception can be very, very broad, just based on where their probable cause that it is. And keeping in mind that the justification here is the mobility of the vehicle and the reduced expectation of privacy associated with their use of public roads, regulations, and most contents of it are already in plain view. At this point, we have covered a number of exceptions that could potentially enable law enforcement to search a vehicle. And it is extremely important that with each exception, you understand the requirements in order to apply that exception. You also need to know the justification or the underlying reasoning behind that particular justification. That will help you to determine whether or not, it'll help you remember the scope of that exception. For instance, with the search incident to a lawful arrest, you know that since weapons and evidence is the justification for it, it'll help you remember the scope of that particular exception. And it is extremely important that you understand the scope, because provided the police officer stays within the scope of the exception, then other evidence that he finds that is within plain view, provided he discovers it while he is where he has right to be, i.e. within the scope of the justification for the search, and it is immediately apparent that it is evidence of a crime or contraband, then he would be able to seize that evidence. So we've talked about the frisk of the vehicle under Michigan v. Law. Keep in mind, this is prior to any arrest. This is after a police officer has stopped the vehicle and has reason to believe, based on some specific and articulable facts, that the vehicle rather contains some sort of weapon that the person could access and use against the police officer. That would justify the police officer in being able to search that area where he believes that vehicle, that where the weapon may be, and particularly in that passenger compartment in the container. So we know that in Michigan v. Long, the police officer saw the knife on the floorboard, and he had reason to believe that the vehicle did contain that weapon that could have been used against the officer, and that justified him in being able to search the passenger compartment of the vehicle. Additionally, we've already discussed the search incident to a lawful arrest that occurs when the individual is inside of the vehicle. Again, this is another way in which police officers would be able to search inside of a vehicle if the person that they are arresting is in the vehicle at the time in which they are arresting them. Then the officers may be able to search for weapons that the person may be able to use against the police officer, or for evidence that the person may be able to conceal or destroy. Here, scope here is an important issue, because we know that the search incident to a lawful arrest when the person inside the vehicle is limited to the passenger compartment and containers inside of the passenger compartment, whether they are open or closed, and regardless of ownership. Also keep in mind the limitations that have been placed on this in the Gantt case, where if the person has been removed from close enough proximity to the vehicle such that they can no longer reach or access the passenger compartment of the vehicle, then the officers would not be justified in searching the vehicle under the search incident to a lawful arrest. That search is not automatic, and that is based on the justification for it. And as I told you before, you have to remember the justification, because that helps guide you in terms of what the scope is. So keeping in mind the justification being the weapons and possible evidence, it allows you to understand that is going to be that area in which the person may be able to access weapons or evidence inside the vehicle. So if they are no longer in close proximity to the vehicle, that does not exist. However, we know that there is a possibility that if the vehicle contains evidence of the crime for which the person has been arrested, then they would be able to search the passenger compartment anyway, or the vehicle anyway, even if the person has been removed from proximity of the vehicle. And we've just finished covering the automobile exception, which is another way in which police officers may be able to search an automobile. The automobile exception, as we just covered, requires probable cause that the vehicle contains evidence of a crime or contraband, and the vehicle must also be readily mobile in order for the automobile exception to take place. Additionally, we know that the scope for the automobile exception is anywhere in the vehicle where probable cause exists, wherever that may be. It can be in the trunk, the gas tank, tires, containers, regardless of ownership, open or closed. If the probable cause exists that there is evidence of a crime or contraband in there, then the officer may search it. A little bit later on, we'll be talking about the inventory search and the circumstances that must exist in order for a police officer to search an individual or to take an inventory of the vehicle, which is considered as a search of the vehicle. But all of these are different ways in which an officer could potentially access the contents of a vehicle. So just because what the requirements of one exception may not be met, you have to go through the different exceptions to see whether the requirements of that particular exception has been met, and you also have to look at the scope to determine whether or not the police officers remain within the scope of that particular exception. And we know that based on the plain view exception, if while in the scope of the exception, the officer sees evidence that he knows is immediately apparent that it's evidence of a crime or contraband, then he may seize that evidence as well. Now let's talk a little bit about exigent circumstances or hot pursuit. Hot pursuit is a primary category of the exigent circumstances. When exigent circumstances exist, no warrant is required, but you still need probable cause. Officers may even enter a person's home if exigent circumstance exists with probable cause. You're still going to need probable cause even if you claim exigent circumstances exist. The rationale here is that in the time it would take to get a warrant, some harm might occur that results from hot pursuit or harm to officers or others, or the risk or destruction of evidence. And some of the cases that we've already covered, this is really a review of some of these cases. It's the Thompson case on page 325, where the mother killed the father, then called daughter, who subsequently called the police. Our Brady case that we covered on page 331, where the girl stabbed her boyfriend, then had the neighbor call the police, and they subsequently found the bloody scissors and a shirt in the closet. And also the Hayden case, where the guy committed a robbery, then immediately ran into the house while the police were in hot pursuit. In the Hayden case, if you recall, where the robbery occurred, the court held there that the Fourth Amendment does not require police officers to delay in the course of investigation if to do so would gravely endanger their lives or the lives of others. Speed here was essential, and only a thorough search of the house or person and weapons could have ensured that Hayden was the only man present and that the police had control of all weapons which could be used against them or to effect an escape. And clearly in that case, we had a serious offense where the police were on his tail in a high-speed chase, and he immediately arrived at the evidence, and the police were immediately on his tail. So in that case, we have a situation where hot pursuit exists. And based on the exigency of those circumstances of him posing a possible danger to the lives of others, the court held that the exigency existed for them to make the entry into the home. Now, in the Thompson case on page 325, in this situation, the mother killed the father and called the daughter, who subsequently called the police. And the court held that police may make warrantless entries into premises where they reasonably believe that a person within is in need of immediate aid, and that they may make a prompt warrantless search of the area to see if there are other victims or if the killer is still on the premises. So here we're looking at a situation where the police officers reasonably believe that someone is in immediate need of some sort of aid. It's a life-threatening situation, but it is going to be limited only to going in to make that determination as to whether there is a person who is in need of some immediate aid, and then they must exit the premises and then go back and get a warrant if they want to search that residence. And additionally, here we're talking about certain situations where there are legitimate public safety concerns. Okay, so you have the person inside in need of immediate aid, or we're waiting to obtain a warrant would gravely endanger the police or lives of others. So you want to see if other victims or the killer is on the premises. Hot pursuit doesn't include minor crimes, okay? We know that from the Brady case. Hot pursuit, we're talking about serious crimes where the person poses a danger to the public, or poses a danger to the officers or to possible people inside. Keep in mind, at the time when officers are in hot pursuit and someone goes inside of a residence, they don't really even know if that's their residence or not. That person could be inside holding those individuals hostage, and the police, who are on their tail, so to speak, are justified in being able to go in there in order to arrest that person if they have probable cause. So the police officers are justified in trying to prevent the imminent escape of that suspect who they have probable cause to believe has committed a crime and who may pose a danger to the officer or others. And that is the exigency of the situation. So, in hot pursuit, for police to stop in the middle of a chase to get a warrant could allow the suspect to get away, destroy evidence, or to create a dangerous situation for the police or members of the public. The suspect must be aware that he is being pursued in order for that to exist. In some situations that are seldom used, the police officers may be able to um, go in based on certain evanescent evidence, certain vanishing or evaporating type of evidence. It is used seldom as exigent circumstances, but depends upon certain factors. Probable cause that the evanescent evidence is inside, some specific articulable facts that the evidence will be destroyed or removed prior to obtaining a warrant. The circumstances of destruction cannot be avoided, nor has been created by the police. Danger to police while guarding the site, and information that the possessor of the contraband is aware that the officers are on the trail. And in some of those rare certain circumstances, um, the possible destruction of evidence could, or evaporating because the person could possibly destroy it, could satisfy that need for the exigent circumstances in order to allow the officers to be able to go in and search and seize the evidence without obtaining a warrant. Let's talk about the inventory exception. The inventory, um, this inventory exception is sort of an administrative type of exception to the warrant requirements. And let's take a look at some of the cases that demonstrate what's required for the inventory exception to exist. In our Sims case, the defendant was arrested for DWI after the officer found him on side of the road, slumped over the steering wheel with slurred speech, smell of alcohol. The vehicle was towed to the station and inventoried where marijuana was found. The defendant sought to suppress the marijuana. The issue here was under what circumstances and what requirements are necessary for the inventory exception to the search warrant to apply. For the inventory exception to apply, the state must prove that impoundment of the vehicle was necessary. Inventory of the vehicle's content was necessary. It was reasonable in scope, not done as a ruse to get evidence. The factors to consider to determine if a true inventory search has been conducted: the vehicle could not have remained safely at or near the place it was stopped. The search was not conducted in the field. The tow truck was called before the search was commenced. Formal impoundment procedures were followed. The vehicle operator was asked if he consented and advised that failure to inventory would absolve liability on the department, and arrangements made for someone else designated by the driver to take possession or custody of the vehicle. Now, keep in mind, these are relevant factors that the court will consider in determining whether or not it was a true inventory search. Okay? And because when we're looking at the inventory exception, we want to ensure that the impoundment was necessary, that inventory was necessary, that it was not done as a ruse to get evidence, and it was reasonable in scope. Now, when we say that it was not done as a ruse to get evidence, what we mean is that the inventory exception cannot be used as pretext. Okay, we've talked about pretextual stops under Wren, and the court was very clear in Wren that in situations in which the search or seizure is not based on probable cause, such as an inventory exception, then it cannot be used pretext. But if you have a situation where you have objective justification, such as probable cause that a crime has been committed, or probable cause that that person has violated a traffic regulation, then that the pretext is okay. But the courts were clear in stating that you can't use inventory search or other searches or exceptions rather that are just based on a balancing test or otherwise when there's no probable cause as pretext for another search because you think that perhaps the person has drugs in the car, you know that he's a drug dealer or whatever the case may be. So you can't use it as a ruse to get evidence, and it has to be reasonable in scope based on the circumstances that justify it like anything else. And of course, It has to be necessary to impound and necessary to inventory it. And all of these factors will help you make that determination whether or not, it could have remained safely where it was, and whether it was conducted in the field or the tow truck was called, and if it was done pursuant to impoundment procedures and all of those different things. Considering all of those factors, the court found that in this case, it was a true inventory search. They stated that the vehicle could not have remained safely where it was. The tape player and music tapes were inside, subject to vandalism or theft. Where it was parked could have obstructed view of other drivers. It was not searched at the scene. The officers radioed for a tow truck. The search was conducted an hour and a half, 1.5 hours after arriving at the sheriff's office. Formal procedures were followed, including a standard form for inventory. However, here the officer did not ask defendant if arrangements could be made for someone to get the car or to consent to the inventory search. So because these are relevant factors, all of them don't have to be met. So although the officers didn't ask him if someone else could come and get the car, there were several other factors here that were met. Now, so if you're looking at a situation, if you're looking at a hypothetical or even a real situation, and you're asking yourself, is impoundment necessary? Is inventory necessary? You're trying to keep in mind that whether it's necessary is whether or not the vehicle possibly claims some valuables that ultimately the officers, they want to protect themselves from claims of lost or stolen property. So if the officers are able to look in there and see cassette tapes, CDs, or laptop or other things that might be left in the vehicle, something valuable, it might even be rims or something, then impoundment is going to be necessary in order to, and well, the inventory is going to be necessary in order to make a list of all those things inside the vehicle. And then we also want to look at where the vehicle is. If it's on a busy street, if it's on rush hour, if it's obstructing view of other drivers, then you need to impound that vehicle in order to remove it from the location, and because it poses a safety concern to other drivers on the street. So the court looks at all of that in determining whether this was a real and legitimate inventory of the vehicle in order to determine whether or not the exception applies. It can't be done as a mere ruse in order to get the evidence. These searches are based on special needs beyond law enforcement and are justified as administrative types of searches. They are to protect property of arrestees and to protect themselves from claims of lost or stolen property. The decision to impound is based on other than suspicion of evidence of criminal activity, and it must be conducted pursuant to regulation, a statute, or department policy and procedures which control police discretion. So this is an administrative type searches, and with all of our administrative exceptions, we do have some special need outside of ordinary law enforcement. In this case, of course, protecting police officers from allegations of lost or stolen property, and you're just weighing that against the individual's infringements on the person's own privacy interests. And based on that, the courts have found that this is a valid search without a warrant. So that's another exception. There's only one exception left that we need to talk about, and these are pretty much other types of administrative types of searches. And we already talked about the fact that these are searches that the U.S. Supreme Court, it's a category of searches that the U.S. Supreme Courts have deemed to be reasonable by applying the balancing test, where they are balancing the government's interest in some special need outside of ordinary law enforcement against the intrusion on that person's own individual liberties. The U.S. Supreme Court has applied the reasonableness clause of the Fourth Amendment to searches and seizures conducted for purposes other than traditional criminal law enforcement. These searches by government officials for a legitimate administrative or regulatory purpose, a special need. If the search is justified by a special need other than traditional criminal law enforcement, the court applies a balancing test to determine reasonableness. And in that balancing test, they weigh the state's interest or the need for the particular search or seizure against the degree of intrusion. And if the court finds that the government's interest in conducting that particular search or seizure outweighs the degree of intrusion, then ultimately the search or seizure is reasonable. So This entire category is based upon balancing the government's need against the intrusion, and we know that whatever the government's interest is, it must be a special need outside of ordinary law enforcement that you're weighing against the level of intrusion. So let's talk about a few cases in which the courts have utilized the balancing test in upholding searches. Let's begin with the Wyman case. The plaintiff was a welfare recipient who refused to allow the caseworker to visit her home in accordance with the Department of Social Service procedures for continuation of the receipt of benefits, but she agreed to meet them elsewhere. Following a hearing, her benefits were terminated. The court held that it was a reasonable administrative tool. It serves a valid and proper administrative purpose for the dispensation of the AFDC program. It was not an unwarranted invasion of personal privacy. It violates no guarantee by the Fourth Amendment. When looking at the rationale in the case, the court considered, of course, the state's interest and stated that the state's interest in ensuring that tax-produced funds are being used for its intended purpose. The public, like a private person, wants to know how charitable funds are being used. The procedure in place so as not to be terribly intrusive. Here we're looking at the intrusion side. When we talk about the state's interest, we have the interest in knowing where these charitable funds are being used. And they're saying that you need to be able to do that by going to the person's residence because there are certain things the money is supposed to be used for. There are certain requirements as to who can live there. We need to make sure that you live where you say you're living and so forth. And you're weighing that against the level of intrusiveness. Here they say that it is minimally intrusive. They give notice by mail of the time. Although there were claims of other more intrusive practices, the court found that those individuals were not before the court. The information couldn't be obtained any other way. This is the only way to verify actual residence, living conditions, and other factors. It's not a criminal investigation, not subject to criminal penalties for refusal, similar to the IRS analogy. So the person, you certainly can refuse. So they certainly give, even though you may need the funds, that certainly gives you some, minimize the intrusion a little bit because it's not something that has to happen. You're not going to be subject to criminal investigation or criminal penalties. You would just lose the benefits. The warrant requirement, the court said, would not alleviate any of those concerns, which could be even more intrusive and could certainly be at any time and without notice if they were to get warrants. So the warrant requirement would only be more intrusive, the court says. So therefore, the court found that it was a reasonable administrative tool. It served a valid and proper administrative purpose for the dispensation of the AFDC program. It was not an unwarranted invasion of personal privacy. It violates no guarantee of the Fourth Amendment. So applying that balancing test of the government's interest in having some special need outside of ordinary law enforcement and weighing that against the level of intrusion that they found to be pretty minimal considering the circumstances in which it's done, it was a valid search. And keep in mind, that is a search because you have state workers, you have your state actor coming into the person's home. They're talking to them, they're seeing where they live, they're looking at the circumstances. So that is a search because they're entering the home where the person has that reasonable expectation of privacy. In another case, the Devers case, Southern University student was expelled for drug possession following a dormitory sweep pursuant to a policy that all students were required to sign while living on campus. The student claimed it was an unconstitutional search. The court held that the regulation authorizing warrantless searches of a dorm room was invalid and unconstitutional. In coming to its conclusion, the court held that students don't shed their constitutional rights at the schoolhouse door. A student who occupies a college dorm room enjoys the protection of the Fourth Amendment. A dorm is a student's house for all practical purposes, and he has the same interest in privacy of his room as any adult has in privacy of his home, dwelling, or lodging. The room is his home away from home, and any student can reasonably expect that once the door is closed to the outside, his or her solitude and secrecy will not be disturbed by government intrusion. Similar policies had been upheld at other institutions such as Utah State University. Specifically, it states that its purpose is for maintenance of university property, health and safety of students, and maintenance of discipline in an educational atmosphere. The Southern University policy allowed police to search without a warrant, but it did not include any administrative purpose. There was no non-law enforcement purposes. Southern would have had to show that the search furthered its functions as an educational institution, separate and distinct from that served by the Louisiana criminal law. So, in other words, you can't have a policy that allows the state actors, so it may be the dorm mother or some other employee of Southern University who is considered a state actor, go into the dorm room, which is considered that person's home. If it's without a warrant, then if you, in order to comply with this administrative type of exception to the warrant requirement, there it must satisfy the balancing test, and the balancing test is going to be satisfied by furthering only if this search, which is the entry, this search furthering some special need outside of ordinary law enforcement. You cannot go in just to look for criminal activity. And some special needs outside of ordinary law enforcement, the court says that we're looking for something that furthered its educational institution, or its purpose as an educational institution. And the other, Utah State University, specifically referred to maintenance of university property, health and safety of the students, and maintenance of discipline in an educational atmosphere, which is a legitimate purpose, to be able to go into the dorm room, make sure that the property is still there on campus, make sure that it's not being damaged in any type of way. We're making sure, we also want to make it sure that we want to ensure the health and safety of the students, and also the discipline and decorum on the university campus. So it all boiled down to having that policy and stating that that would be the purpose of any type of search of the dormitory rooms. So it may have been different had the university been able to show that the search actually did further its functions as an educational institution, as some of the other universities which have been upheld have been able to show. Evaluating administrative service searches, you apply a balancing test. When the court evaluates the reasonableness of the searches, it looks to whether there's an interest outside of ordinary law enforcement, and whether the practice that furthers that interest outweighs the level of intrusiveness. Taking a look at the Vernonia School District. Here, high school athletes were randomly drug tested pursuant to a policy implemented with unanimous approval of all parents in attendance. The policy required each student and their parent to sign a consent form agreeing to the policy. The suit brought after a student and a parent refused to sign the form. The court ultimately held that high school athletes can be drug tested. Participation in sports is not a right, but a privilege. Ultimately, this is a search, but in determining its reasonableness, they balanced it. There was a balancing intrusion on Fourth Amendment interests against its promotion of legitimate government interests. So again, you apply the balancing test in order to determine whether or not the search or seizure was reasonable. So you want to balance the Fourth Amendment interests, what government interest is at stake here, and we're weighing that against the level of intrusion. A search unsupported by probable cause can be constitutional when special needs beyond the normal need for law enforcement make the warrant and probable cause requirement impracticable. Special needs do exist in the public school context. In coming to a conclusion, the court considered three things. They first looked at the nature of the privacy interest and determined there was a decreased expectation of privacy in this situation. They also looked at the character of the intrusion, the relative unobtrusiveness of the search, and also the state's interest. With respect to the nature of the privacy interest, the court said that there was a decreased expectation of privacy. In a public school, they are subject to various exams, vaccinations. The expectation of privacy is even less for athletes because they said that it's not for the bashful. They have to take showers together. They have to suit up. They have to, maintain their certain grades and GPAs and so forth. And so athletes subject themselves to those increased regulations, the insurance coverage, physical exams, rules for conduct, dress, training hours. So all of that was considered the nature of the privacy interest. Then they looked at the character of the intrusion because we know that the intrusion has to be minimal. And so factors affecting the level of intrusiveness here is that the policy is it was based on a policy, and it was not something that was just done randomly or something that was just, done at any given time, but it was a specific policy that provided it. They looked at the manner in which the urine tests were taken and information it reveals, drugs only. It didn't determine if you were pregnant or if you were diabetic or anything like that. Disclosure of other drugs taken before the test, you were able to tell them that so that they would already know ahead of time. They had specific methods in the policy for results, so you already knew that ahead of time. All of that would help to minimize the intrusion. When you signed up, you knew that these things were going to happen. These were not sort of sprung on you at the last minute, which is certainly going to be a little bit more intrusive on an individual to say, well, I didn't know this was going to happen, or I didn't know that was going to happen. And then in addition to looking at the character of the intrusion, we want to look at the state's interest because the state has the policy to conduct this search, has to further a state's interest outside of ordinary law enforcement. It can't be just to look to see if you're committing or using drugs so that you can be arrested. It cannot be to look for criminal activity. It has to further a state's interest outside of ordinary law enforcement. So here, they stated that the state's interest as a guardian for children, the interest in educating students and being sure that drugs are not a part of the system, in deterring drug use. Athletes, the court said, there's a risk of immediate physical harm to drug using athletes as high, if they're high, or those with whom he is playing his sport. So the state has an interest in being sure that these athletes, when they're going to be in close proximity to the other athletes out there on the playing field or wherever they are, that they're not high and using drugs to potentially hurt themselves or the other athletes. And with that in mind, that's the state's interest in being able to conduct this search, taking these drug tests, would further that interest, the state's interest in being in this guardian position and trying to keep in mind its ultimate goal of educating students while allowing them to participate in athletics, but keeping them from being able to pose some threat of harm to themselves or the other athletes on the field. So taking those factors into consideration, the court found the policy reasonable and constitutional. It was a search, but applying the balancing test, it was reasonable. In the Chandler case, this is another case dealing with drug testing, but not dealing with students. Here, this case involved a Georgia statute which required candidates for certain officers to certify that they have taken a drug test and that the test result was negative within 30 days of being placed on the ballot. The court held that this was a search, and under these circumstances where public safety is not genuinely in jeopardy, it is precluded by the Fourth Amendment absent individualized suspicion. The court distinguished this case from drug testing where it has been sustained, such as in Vernonia. That's where the students have less expectation of privacy, and then you have a state's interest as guardian and tutor of the children and in the safety of the children. In Skinner, where it's also been upheld, there was drug testing of railroad employees following accidents. It regulated a pervasively diminished expectation of privacy, evidence of drug use, relation to the accident. So all of that in that particular scenario, it's a heavily regulated industry where after there's been an accident, the railroad employees would have to be drug tested in order to be sure that they were not using drugs. Also, the Von Brab, the U.S. Customs employees who seek transfer or promotion to certain positions directly related to drug enforcement. That was a high-risk position, and there's a compelling state interest to be sure that if you're going to be in positions directly related to drugs, that you're not using drugs. So in all of those situations, there was a state interest outside of law enforcement, not just looking for people using drugs. For whatever reason, there was some compelling interest that the state had in order to conduct the search. The court held that although intrusion was minimal, there was no special need in this case. There had not been showing of a drug problem among candidates. It didn't perform high-risk, safety-sensitive tasks. So there was really no special need to conduct this type of drug test of candidates. So it was minimal intrusion, but it still was more than the need here because the state had no interest in conducting drug tests under these circumstances. The court also addressed other searches where public safety was substantial and real: airports, entrances to courts, and other buildings. Okay, so absent a finding that the search is upheld, under the balancing test, the court is saying that you have to have some individualized suspicion, and it has to comply with the warrant requirement. But here in these situations, the court are finding that these are in fact searches. They implicate the Fourth Amendment, but because the court is finding that they are still reasonable, which we know the Fourth Amendment ultimately requires that searches and seizures be reasonable, and that they are finding that these are reasonable searches by applying this balancing test of weighing the state's interest against the level of intrusion here. And these are some other situations, just a few additional examples in which the court have found that searches have been upheld when conducted without grounds for suspicion of particular individuals, no individualized suspicion. And some other situations are the fixed border patrol checkpoints. And we talked about this Martinez case quite a bit early on in the semester when we were talking about checkpoints. But here we had the state's interest of protecting the border, from illegal aliens. And then they were weighing it against the level of intrusion and found it to be reasonable. The sobriety checkpoints, the court had the state interest of, getting drivers off the street who pose an immediate danger to the other drivers if they might have been intoxicated, and weighed that against the level of intrusion. And in that case, the intrusiveness we were looking at, we were just talking about the fact that they're short, they're brief, they were given advance notice, they were conducted according to policy. All of those were the factors to minimize the intrusion. When weighed against the state's interest, then the court found them to be reasonable. Administrative inspections in closely regulated business, drug testing for student athletes, drug testing for U.S. customs officials. In all of those situations, the court found some special need outside of ordinary law enforcement. Our interest in public safety, our interest in protecting our kids in school, our interest in ensuring that state funds are being used for what the state funds are supposed to be used for. And then there always are procedures in place in order to minimize the intrusion. It may be some advance notice. It's done pursuant to policy. It may be something that you have the option of being a part of or not, or benefits that you're accepting or not, and not making it subject to criminal activity. All of those things minimizes the level of intrusion. And when you weigh that against the state's interest in conducting that particular search, the court ultimately finds that these particular searches are reasonable, even though they are searches without a warrant. We talked about, the McHugh case, where the court upheld stops for checking hunting licenses and for gang queries as the least intrusive means to effectively achieve the state interest in that case. And again, that was yet another situation where the court found that there was a special need. Of course, in that situation, it was specifically dealing with protecting our wildlife, which here in Louisiana, of course, we know is in our Constitution, is an important part of our state. So if the search is justified by a special need other than traditional criminal law enforcement, the court applies balancing tests to determine reasonableness, the state's interest, or the need for a particular search or seizure versus the level of intrusion. So with that, we have covered all of the exceptions to the warrant requirement in our mnemonic, our praise cash mnemonic here. We've looked at PRAISECCASH. So we've looked at the plain view exception, the regulatory administrative exceptions, the arrest search incident there too. We know the search incident to arrest of the person, search incident to arrest when they're in the vehicle. We've talked about the inventory search, the protective sweep, certain evanescent evidence, which are in limited situations. The court may have held that there may be a search may be conducted without a warrant. And consent is always, of course, going to be sufficient without a warrant. A crime committed in the officer's presence or the arrest made in public with probable cause, of course, the automobile exception, the stop and frisk exception, and hot pursuit exigent circumstances. Those are the exceptions to the warrant requirement. And as we indicated before, that is the third major issue that you must address in a Fourth Amendment analysis after you determine that there has been a search or seizure that implicates the Fourth Amendment. For a search or seizure within the meaning of the Fourth Amendment, you inquire as to whether the search or seizure was reasonable. The compliance with the reasonableness requirement is a warrant. We know that a search or seizure conducted outside without a warrant is presumptively unreasonable. When you go through your warrant requirement, you have to determine whether it's a valid warrant. You look to see whether it's probable cause, whether it complies with the particularity requirement, and all those things. If you determine that there has been a search or seizure and that there is no warrant, then you move, or if it's an invalid warrant because it may not have probable cause, then you move on to the exceptions. And here our exceptions, your mnemonic is praise cash. And in the next lesson we'll be talking about the remedies for when you have a search or seizure within the meaning of the Fourth Amendment. There's no warrant and none of the exceptions apply. In the next video, we'll be talking about the remedy for these searches or seizures without a warrant or an exception, which is the exclusionary rule.